Hi, my name is Robert Shelley with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to discuss whether you can reject a letter of intent. So the quick answer is yes, you certainly can and should if you're unhappy with the terms of it. So letter of intent, also known as an offer letter, it can be provided once kind of negotiations or discussions about a position move forward in the process. So normally how it would work is, a potential candidate would find out about a job either through a job listing or word of mouth, or maybe they were reached out to through a recruiter. There's a discussion of the main points of the position, salary, benefits, that type of thing, location. And then once there's interest on both sides, many employers will then offer the letter of intent or the offer letter. And so in that is a description of kind of the main points of the employment relationship. So in most offer letters, there will be, start date, location, length of the contract, which is called the term, maybe brief discussion on how the contract can be terminated. Obviously compensation. So is there a base salary? Are there bonus opportunities? Is it net collections, commission-based, RVUs? It just, how it would be a brief description. It wouldn't go into a long, 4 paragraphs about comp. If malpractice insurance is necessary, who pays for that? And then who pays for the tail insurance if that's necessary as well? Are there restrictive covenants? So the restrictive covenants are normally non-disparagement, a non-solicit, a non-compete, and it might go through briefly, like this is how long they'll last, and maybe this is the geographic restriction associated with the non-compete. And then maybe a brief description of the benefits, health, vision, life, dental, disability, retirement, and maybe expenses. What expenses are the employer going to pay for? So that's kind of what would normally be in an offer letter. And so the candidate, when reviewing this letter, if the terms of it are unfavorable or maybe not what the candidate was looking for, they can absolutely say, no, I'm not interested in this. I'm not going to sign this. Now, I wouldn't suggest just flatly saying, no, I'm not taking this job, take a hike. It would simply make sense to counter. So you can say, I'm not going to sign this offer letter. However, these are the things that would make this opportunity good for me. So if you're offering 200 base, then maybe I want 250, or a signing bonus of 10, and I want a 20,000 signing bonus. And are you going to offer relocation assistance if I have to move into a new city? So these are all things that should be done at this stage. And so even though a professional has been given an offer letter, it doesn't mean that's the end of it. And then even further, if you come to terms with the offer letter, what will then follow will be an employment agreement. And so even if an offer letter has been signed, unless there's language in there that says this is a binding offer letter, no terms can be changed, which you will almost never, ever see. Once you get the employment agreement as well, you can still negotiate terms. So you need to think strategically, all right, am I happy with what the offer is? And then what is my leverage in negotiating new terms? I would suggest never signing an employment agreement that you're unhappy with. So even if you reject the offer letter, and even if you reject the employment agreement, it doesn't mean that the negotiation is over with. As long as the professional is reasonable in what they're asking for, I find most employers are kind of expect at least some kind of negotiation when they're bringing in new candidates. I mean, it is the expectation. So, but once again, as long as they're reasonable, asks. If someone is asking for a 200% increase in base salary, well, the employer is likely going to go, look, you are delusional, and we are going to move on to a different candidate. So it helps for the professional to understand what the industry standards are in their profession. That way they can ask for reasonable changes to the contract. There are also many times where you'll get the brief details in the offer letter, and then when you see the actual written language in the agreement, it substantially changes what it looked like in the offer letter. So maybe if it just briefly mentions there will be a non-compete, but then once you review the employment agreement, it's a terrible non-compete. Maybe you're expecting a 1-year non-compete and they offer 3, or you're expecting a small geographic radius of 10 miles and they came back with 100, or something like that. That can be the change between, this is a great offer, to there's no chance I would ever accept this job. So there can be negotiation all the way through the process up until the professional signs the employment agreement. At that point, those are the terms. So you need to make certain before you sign anything that you're okay with what is in the agreement, and then understand there will be obligations after the employment relationship ends as well. So hopefully that was helpful. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can always reach us through our website, ChelleLaw.com. That's CHELLE law.com. Anyway, appreciate you watching the video. Thanks.